Good morning. Good morning. I'd like to welcome all of you today to our program on judicial education. My name is Gary Myers, and I'm the Dean of the University of Missouri School of Law. For those of you from out of town, I want to welcome you to Columbia, and I'd like to welcome all of you to today's symposium. I had dinner with the speakers last night, and I can tell you that we have a really outstanding group of scholars and judges. And I think it'll be an outstanding program, and I know it'll be a real treat for all of us. So I'm going to get us started, first of all, by introducing the person who made all this possible. Professor Stacy Strong here on our faculty is the organizer of this symposium. She's done a wonderful job with it, and I'd actually like to start with a quick round of applause to thank her. Job well done. And without any further ado, I bring you Stacy.
Thank you, Dean Myers, and I want to welcome you all to a very early morning on a Friday, and not the best of weather. Traditionally here at our annual symposium, we have wonderful, glorious autumn weather, and unfortunately this year not so much. As Dean Myers said, I am Stacy Strong. Last I checked, but of course it's early in the morning, so one can never be sure of these things. This is a somewhat unusual symposium for the Center for the Study of Dispute Resolution. So often we focus on alternative forms of dispute resolution like mediation and arbitration and such, but this year we are focusing very much on the judicial process and more importantly on judicial education. This is a topic that has not been studied much by academics, and yet it's incredibly important because of the role that judges play in our society. So I thought that it was an important subject to look at after my year at the U.S. Supreme Court as a fellow, and I was based at the Federal Judicial Center with Judge Fogle. I had the fine, it was quite an honor. I literally had the office next door, and so I saw the comings and goings, and I actually learned that Judge Fogle, small secret, he likes chocolate about 10 o'clock in the morning, I think it was. I'm not quite set my clock. Hopefully he did that for me. I was at 3 o'clock. I would head on out to the little bowl and hoping very much that nobody saw me. Yesterday we had a Works in Progress conference that was fantastic, and I'm very pleased to see a number of the participants here. It was a very diverse program with people coming from different disciplines, not just the law, coming from different countries, not just the United States, and also coming at the issue of judicial education and the role of judges from a variety of perspectives. And I thank them for coming all this distance and for coming here at 8 o'clock in the morning on a wet morning to hear our panelists, who are going to be fantastic. I want to mention a few notes of things. This symposium could not have happened. It was not possible without the assistance of the Vice Provost's Office for International Affairs, the International Center, and the Transatlantic Center. Of course, Laura Coleman, who I suspect is still running around frantically taking care of all the details that go on behind the background of these types of events. And of course, the Journal of Dispute Resolution students. So again, in their absence, if they're not here, but if they are here, a round of applause for them. Of course, this is the annual symposium for the Center for the Study of Dispute Resolution. So I want to introduce our director, Raphael Helly, who this is his first year as director, but he's been here at the law school for a number of years doing fantastic work, primarily in the area of labor arbitration and labor law. He's going to tell us a few words about the CSDR.
Thank you, Stacey. And thank you all for being here. Again, we are delighted to have you here. Thank you for taking time from your busy schedule to help us with this symposium. This is an important year in the life of the center. We are celebrating our 30th anniversary. So we have been around for a long time, and we have been blessed to have the support of the law school faculty, and the University of Missouri. And for that, we are very, very thankful, and we try to be good stewards of the resources that we are given, and that includes presenting this symposium on a yearly basis. We have been blessed by having been led by 3 outstanding directors over the life of the center. Professor Len Riskin, who was the inaugural director, the late Dean Tim Hines was director as well, and Dean Bailey, who is here with us, led the center for many years. And they have set up, I think, a great foundation for what we are today and what we hope to continue to be. This symposium is an important piece in that history, and you are part of that history now, whether you want it or not. You are part of what we do, and the idea of thinking about judges and how they are trained in dispute resolution and doing their jobs, and in doing their job is an important piece of what we want to accomplish. So today we start that conversation. That conversation will continue through the symposium issue that will be published, in which the articles of the presenters will appear, and hopefully that will just be the first step in a conversation that will take place in years to come. So again, thank you for being here. We appreciate your presence. We hope that we can make your stay here as comfortable and pleasant as possible. Again, thank you to Stacy for organizing this program.
Thank you. Now back to me literally for the rundown, the procedural logistics of the day. We're going to have 3 panels that will all be in here. We're going to have 2 back-to-back. We'll have a short break. We're going to need to set up some PowerPoints for the 3rd panel, and then the 3rd panel will return in here. Then we'll have a short break as we retire to, not retire in the means of going home forever and kind of playing some golf, but retire in the Oxford and Cambridge sense back from my days. We will retire to a different room, to room 7 for Judge Vannon's keynote speech. I'm going to take this opportunity to introduce the 3 moderators to you so that you have a bit of an idea of what they do. Dean Helly is going to be, he was Dean, one of the associate deans last year, so I'm having problems shifting over back to Professor Helly. Professor Helly is going to be moderating the 3rd panel, and as I said, he's the director of the center and has advanced degrees in labor relations. Our second moderator today is going to be Jim Levin, who is the Associate Director for the Center for the Study of Dispute Resolution. He has his bachelor's degree from Macalester and his JD from Northeastern. Jim is very much a specialist in mediation, runs our mediation clinic, but also sits as a mediator and is fantastic. If you ever want to see a natural at work, that would be Jim, in addition to some excellent training, I should say. He does a lot of training in mediation for our center, and he also is co-director of our study abroad program in South Africa and has been there a number of times. So if you want to talk about good South African wines and a few other subjects, Jim's your man. And then our moderator for our kickoff session is Chuck Henson. Chuck has a bachelor's degree from Yale and a JD from Georgetown. He is a senior fellow in the Center for the Study of Dispute Resolution and trial practice professor of law. Chuck is indefatigable in preparing our students for our competitions, and last night he was working into the wee hours of the night preparing them for a mock trial competition. So he does a fantastic job with our competitors, and he has a lot of experience litigating in, dare I say, real life. He was at Kutak Rock as a partner in Denver for a number of years. He's also at the Attorney General's office here in Missouri at certain points in time. So I dare I say I've seen him in action, at least prepping these students, and he's not somebody you want to have on the other side. You want him on your side whenever you're litigating. So I will let Chuck take over the first panel. Thank you so much.
Thank you, Stacy. Well, good morning, everyone. It's my pleasure to introduce to you, and I'm going to start on my left, Professor Chad Oldfather, who's a professor of law at Marquette University School of Law. Professor Oldfather teaches criminal law, evidence, constitutional law, constitutional theory, and a seminar titled Judging in the Judicial Process. He was educated at Harvard, received his JD from the University of Virginia School of Law. His scholarship, covering judicial institutions and judicial decision-making, has been published in the Georgetown Law Journal, Vanderbilt Law Review, George Washington Law Review, just to name a few. The American Academy of Appellate Lawyers awarded him the Howard B. Eisenberg Prize in 2004, and I could literally go on and on. Immediately to my left is Professor Robert Bone, the G. Rollie White Teaching Excellence Chair in Law at the School of Law at the University of Texas, Austin. Is it Hook'em Horns?
It is Hook'em Horns, but I would hesitate to say it here.
Then go Aggies. He was educated at Stanford and received his JD from Harvard. He's a leading scholar in civil procedure, complex civil litigation, and intellectual property. His list of publications includes leading law journal articles, books including The Economics of Civil Procedure and a case book, The Law of Class Actions, and Other Aggregate Litigation. And the list of publications, and I measured it, is literally as long as my arm, so I'll stop there. He has been recognized not only for his scholarship, but also his excellence in teaching. And finally, I discovered through research that he has a wonderful baritone singing voice.
You learned something about yourself.
And you do not want to hear my singing voice.
Never mind.
Consider yourself fortunate that that will not be part of what I do here. So I want to, of course, begin by thanking Professor Strong, Professor Haley, Dean Myers, the faculty, the staff here at the University of Missouri Law School for the invitation and for their hospitality. I'd particularly like to thank the members of the Journal of Dispute Resolution for their contributions to making this an incredibly well-run conference. So it's been a terrific experience so far, and I'm looking forward to today as well. This panel was charged with answering the question, what does it mean to be a judge, which is a fairly broad question, and I'm going to answer it, at least for the most part, in a fairly broad way, starting out at what we might characterize as a 30,000 foot level. I will bring it back to judicial education and some implications, I think, of my discussion for judicial education towards the end. So to characterize it further, in his book, The Common Law Tradition, Carl Llewellyn, whose name I'm going to be invoking several times this morning, described his mission as, quote, preaching the neglected beauty of the obvious. And what follows is, I think, offered somewhat in that spirit. So I hope you will absorb that spirit and come along with me for this ride. So again, our mission is to address the question, what does it mean to be a judge? And that's a question that can be addressed in an awfully large number of ways. One could, for example, interpret it as calling for the identification of the characteristics that an ideal judge ought to have. And indeed, it's not terribly difficult to find lists in which various authors attempt to provide a taxonomy of those characteristics, and there are commonalities among those lists. For example, you'll find things like intelligence, legal knowledge, judgment, decisiveness, and so on. But that sort of approach, though, doesn't seem quite right to me. For one thing, the items that typically appear on such a list are usually offered at a very high level of generality, so that even if we were in this room able to agree on the items that we would want to include on that list, we would undoubtedly disagree as to the particulars of what we meant when we invoked those phrases. So I think that fact, the fact that we would be unlikely to agree on particulars, leads to another set of reasons why trying to provide such a menu would be misguided. And a story related by Llewellyn in The Common Law Tradition helps to make the point. So Llewellyn writes of how 7 of his fellow legal academics were more or less contemporaneously appointed to the bench. And Llewellyn says, here's a wonderful opportunity. And he asks each of them to, in effect, during their first year on the bench, keep a journal of their decision-making process as it unfolds. He says to them, your notes may mean nothing to you, but provide them to me and I'll make some sense of them. And so they all said, sure, I'm game, I'll do it. None of them actually did. So what do we make of this? Well, Judge Henry Friendly, writing later in his famous article, Reactions of a Lawyer Newly Become Judge, passes along Llewellyn's story and says, in effect, of course they didn't. This is because, as Friendly puts it, and I'm quoting, the new judge soon learns that each judge judges differently from every other judge, and that any one judge judges differently in each case. Along those lines, and more recently, Judge Andrew Wistrich cautioned against focusing too tightly on the characteristics of a good judge, because he suggests doing so tends to lead us to overlook the context and the environment in which decisions get made. So one lesson here is that answering a question like, what does it mean to be a judge, is not something that can be undertaken in an acontextual sort of way. We have to be sensitive to differences in the institutional and the procedural settings in which decisions get made, and perhaps as well to substantive and other case-specific differences. But there's another lesson to be drawn from Llewellyn's story, and I think it is the lesson that Llewellyn himself seems to draw, which is that so much of what goes into the process of judicial decision-making is inarticulable, right? The sort of thing that just can't easily be reduced to words, and perhaps can't even be reduced to words at all. In saying that, I should be clear that I, like Llewellyn, am relying on a distinction between making a decision and justifying that decision. We, of course, ask judges to justify their decisions and to use words when they do so. But their ability to do that, to provide an after-the-fact justification for a decision that they have made, does not mean that they can accurately or adequately identify in any sort of precise or comprehensive way the steps that they undertook in making that decision. So what I hope to do in the rest of my time is to build off of these two observations. One, that judging is a very context-dependent activity, as well as one that involves a largely inarticulable process to highlight a central problem, and at some moments I might even call it the central problem, in designing and maintaining judicial institutions, by which I mean to include things like judicial education. So to appreciate the nature of this problem, I'm going to ask you to accept three propositions, each of which I think is largely non-controversial. I'll briefly identify them and then elaborate some. So the first proposition is that the law affords a great deal of discretion to judges. Partly that's express, and partly it is inherent in the nature of doing law. Second, in exercising this discretion, judges are susceptible to all sorts of unconscious influences of the sort that we would regard as illegitimate. Third, at the same time, and here's the part that I think we have tended to lose track of in recent decades, is that good judging necessarily entails drawing on another sort of unconscious influence, what I'm going to talk about in terms of a concept called tacit knowledge, and that this sort of unconscious influence is the kind that we want to cultivate and indeed celebrate. And so the problem involves finding the appropriate balance between the good sort of unconscious influence and the bad sort. So let me briefly elaborate on each of these three components. First, as I suggested, judges have a great deal of discretion. To a large degree, that's because it's expressly delegated, both to trial courts and appellate courts, right? Think of evidentiary rulings. The law of evidence is, in some degrees, just a great big grant of discretion to trial judges. It's maybe a little bit more difficult to see express discretion granted to appellate courts, but I think it's there. We might say, for example, harmless error review involving an essentially discretionary determination of whether this particular error by the trial judge was significant enough to warrant reversal. But this discretion also stems from the inherent underdeterminacy of law. Right? So the saying has it, we are all realists now, so I don't think I need to spend a great deal of time defending the point. The core idea is simply that a lawmaker, whether it's a legislature or a judge, acting at time one, can't fully specify the content of the law, either because of the limits of language. We just can't identify concretely or specifically enough what we want to regulate, or because of the limits of foresight. We can't anticipate all of what might happen in the future, or because of both. The consequence then is that a court acting at time two is going to have room to exercise judgment, either in determining what the law is or how the law applies to the specific situation before the court. Well, that's point one. Point two, in exercising this discretion, judges are subject to all sorts of unconscious influences of the sort that we would prefer they not be subject to. I'll give you a couple of examples. Political scientists have taken the lead in this first, which is demonstrating that judicial decision-making is highly correlated with ideology, which is an idea that has at least become fairly well accepted in law schools, at least among those of us who study judicial decision-making. In similar fashion, psychologists have demonstrated that human decision-making, in general, is afflicted by various cognitive biases that lead people to act in ways that predictably and systematically demonstrate from rationality. And researchers have demonstrated that judges, too, are susceptible to these biases. And these phenomena, too, I think have become relatively well accepted, to the point where I recently presented at a judicial education conference put on by the Federal Judicial Center, at which this very research was presented to an audience of judges who did not stand up and storm out of the room. So far, so good. So on to the third proposition, which is the one, at least, that I think in recent times tends to get overlooked. And the basic idea here is that judging necessarily, and I want to say again, desirably, draws on influences that are unconscious, at least in the sense that they are inarticulable. So the phrase I want to use to capture the idea comes from philosopher Michael Polanyi, who wrote of what he called tacit knowledge. And he encapsulates the concept of tacit knowledge in a phrase that goes, "We know more than we can tell." For our purposes, The central idea is that there are certain sorts of tasks as to which it is impossible to put into words how the task is performed. Polanyi's most famous example is that of riding a bike, right? It's something that we all know how to do, yet none of us could explain with anything approaching clarity how it is that we go about doing it. He also offers up as examples of tasks involving tacit knowledge, things that he calls connoisseurship. And he suggests that common law judging is an example of that sort of task that necessarily involves drawing on tacit knowledge. That phrase, tacit knowledge, has not itself made a large number of appearances in at least the American legal literature. Related ideas, however, have surfaced in a number of places. Llewellyn spoke of what he called situation sense and horse sense. By horse sense, he meant, and I'm quoting here, neither the sense of a horse nor ordinary common sense, but that extraordinary and uncommon kind of experience, sense, and intuition which was characteristic of an old-fashioned skilled horse trader in his dealings either with horses or with other horse traders. By situation sense, he meant the ability to recognize that what at first appears to be a novel situation actually fits within a familiar type. It's an idea that's embodied in one of my favorite quotes from Justice Holmes. Holmes writes, "I have long said there is no such thing as a hard case. I am frightened weakly, but always when you walk up to the line and lay hold, the hide comes off and the same old donkey of a question of law is underneath." Llewellyn and Holmes are not alone. 30 years before Llewellyn wrote the common law tradition, Judge Joseph Hutchison extolled the virtues of the hunch in judicial decision-making, which he described as that intuitive flash of understanding which makes the jump spark connection between question and decision. More recently, although still at this point over 20 years ago, Anthony Kronman wrote in The Lost Lawyer of the craft values involved in lawyering and judging, and of the role of practical wisdom and what he called deliberative imagination in judicial decision-making. Each of these commentators makes clear that cultivating this faculty, whatever it is that they're referring to, requires long experience both in the law and in the task of judicial decision-making. It requires the absorption of cultural norms, the acquisition of working know-how, only some of which can be passed along through articulable rules and principles. And even then, Llewellyn says, the rules not only fail to tell the full tale, taken literally, they tell much of it wrong. And they can be put to proper use only via, quote, ways and attitudes which are much more and better felt and done than they are said. So a sensitivity to these ways and attitudes, I think, can be developed only through sustained exposure to situations and examples. It is, in other words, the acquisition of a craft. All right, so let's review the bidding briefly. We're at a place where the nature of law is such that judges must exercise discretion. The exercise of that discretion is subject to unconscious influences, some bad because the product of improper factors, some good because necessary to doing law. The trick then, and perhaps the answer to our question, what does it mean to be a judge, is to arrive at a place where judges follow the articulable parts of law as far as they are able. And make no mistake, I'm not suggesting that there's not a long distance they can follow the articulate parts of law. But that runs out at some point. And beyond that point, we need to create a world in which the desirable types of unconscious influence have room in which to be exercised, while the undesirable aspects of the unconscious influences are minimized. So that's where things become difficult. That's so for the simple reason that it's not clear that when it is that unconscious influences are good and when they are bad. Take the example of politics. Law, I think it's fair to say, ultimately rests on politics. And so we might well conclude having some political responsiveness from judges isn't necessarily a bad thing. After all, one answer to Alexander Bickle's complaint about the counter-majoritarian nature of judicial review is to show that judicial review isn't completely counter-majoritarian. And that that's so because the political preferences of those who appoint judges continue to manifest themselves in the judge's decision-making. The point is probably even stronger in a state system where judges are elected, in which case we might more openly expect judges' politics to manifest themselves in decision-making. I don't intend to offer a resolution to this tension, merely to identify it and to observe that reasonable minds might well, and do, differ about the extent to which it is desirable to have political influences come into play in judicial decision-making, as well as what might count as political influences. I think the same holds true with respect to cognitive biases, in that one person's bias might be another person's useful shortcut. Here I'm going to change things up on you a bit, and I'm going to illustrate the point by shifting context to, yes, judging in figure skating. I'm going to use that as an example of a process of judging in what philosophers of sport, and yes, there is such a thing, and it has its own journal, called aesthetic sports. Aesthetic sports are things like gymnastics and figure skating and so on, where the performance is being judged. So judges in aesthetic sports, to an even greater degree than judges in law, have to apply highly underdeterminate standards. So, for example, if you're a figure skating judge, you must apply concepts like flow and effortless glide and phrasing and form. Those are the rules you have to work with. Right? As words, they're almost meaningless. Right? They tell those of us in here who don't have any background in figure skating at least almost nothing. They gain meaning only when they're considered in conjunction with this base of tacit knowledge, which takes the form of an internalized ideal of what it is that the perfect skating performance ought to look like. And that gets formed in the judge's mind only through the gradual accumulation of experience and the absorption of the relevant culture. And in the context of figure skating, and this is true for gymnastics and all these other sorts of sports as well, the process culminates in a period of apprentice judging from which a prospective judge can graduate only if his or her assessments are sufficiently similar to those of other more experienced judges in the discipline. Right? So it's quite similar, I think, in lots of ways to the law judge's acquisition of this tacit knowledge. So in a rough sense, there's a right answer to the question of judging in figure skating, right? In the sense that any given skater's performance is going to lie a certain distance away from whatever the ideal performance would look like. Determining how far, though, is an amazingly challenging task. And indeed, it is almost certainly beyond the limits of human cognition to be able to perceive and take into account all of the factors that go into such an assessment, let alone to be able to do so with respect to one performance and then hold that constant in your mind while a series of other performances follow, which you have to grade relative to one another. So not surprisingly, research, and there is a discipline of psychology of expertise in sports officiating, research has revealed that all sorts of biases creep into this process. Studies have shown, not surprisingly, for those of you who have watched the Olympics, the presence of nationalistic and other forms of affiliation bias in figure skating judging. They've shown the existence of something called the order bias, in which later competitors tend to get higher scores even if the order of competition has nothing to do with some prior demonstration of skill, such as performance in a prior round. There are reputation biases. There are all sorts of other biases. What's not clear is whether these biases are as bad as we might first think. Right? Does a nationalistic bias reflect prejudice, or does it simply reflect different stylistic preferences? Is a reputation bias unfair, or is it instead the tool of a judge who cannot fully process the information before him and so seeks to make up the deficit by referring to reputation, which is in some sense the same sense of the skating community that is at the same time the foundation for this idealized performance that's to serve as the ultimate metric. Again, my point here is to highlight rather than to resolve attention and to suggest that it exists in law as well. Judges are undoubtedly susceptible to many of the cognitive biases that psychologists have identified. But it may be that some of those biases end up furthering rather than hindering the functioning of the system. And in any case, we shouldn't make the mistake of thinking that because an aspect of the decision-making process can't be reduced to words, it should therefore be minimized. And again, I think that the study of the judiciary over the past several decades has tended toward the tangible and the quantifiable. That work's valuable. I've done some of it myself. But I don't think we should let our attention to these empirical, quantifiable aspects of judging lead us to minimize the significance of the inarticulable or the ineffable aspects of the process as well. So where we end up, I think, is that one answer to our question, what does it mean to be a judge, then, is someone who walks something of a tightrope and must draw on the good parts of her tacit knowledge while avoiding the pitfalls associated with the undesirable unconscious influences. And of course, since so much of this is taking place beneath the surface, she's not only walking a tightrope, she's doing so in a blindfold. Our job then is to help her navigate that path. So this brings us back to Judge Wistrich's suggestion that we ought to pay more attention to context and to circumstance. Our focus shouldn't be on the individual judge, but also on the cultural, institutional, and procedural context in which she works, and we must keep an eye on changes in those circumstances. So here I'm going to briefly draw on another famous article, Paul Carrington's article of Law and the River. Carrington wrote in response to a then current controversy in legal education, but his discussion is pertinent here. And what Carrington does is he invokes Mark Twain's Life on the Mississippi to draw a parallel between law and a river. Twain wrote about his training as a steamboat pilot, and he discussed the range of knowledge and the depth of experience that's necessary to capably navigate a river. And Twain noted as well that change was constant, and it brought about the need for ongoing study, to the point where if you were a steamboat pilot whose own boat was under repair, you would often travel on other boats simply to keep your knowledge up to date. So Carrington, drawing on this, is right there with Hutchison, Llewellyn, and Cronman in regarding judgment and intuition, what I've called tacit knowledge, as a key component of being a lawyer or a judge. And that tacit knowledge is the ineffable byproduct of accumulation of more detailed knowledge about the law or about the river. Law, like the river, changes. And so, just as with river pilots, keeping a judge's knowledge current requires constant learning and relearning of the sort that can come only through continuing engagement with the material. And here's where I'm going to start to wrap things up with a note of concern. Once, or so we are led to believe, judges had a luxury, which was the luxury of time. It was no doubt a luxury that was occasionally abused, and plenty of that time was certainly wasted, but some of it was surely used for digging into the case law and the record, and for study, and for observing and perhaps even reflecting on changes in the river of law. That time has passed, and the judicial role has necessarily become more managerial in nature. So judges now are perhaps a bit more like the pilots riding along than those who are actually navigating the river, in the sense that it is now, to a great degree, often others, law clerks, who are engaging more directly with the record and the case law. Now, there are a number of critiques associated with that change. One I want to just briefly focus on is whether it has led to an erosion in the base of tacit knowledge that judges must draw upon, and that stands as a counterweight to these less desirable forms of unconscious influence. I think it's an open question. My guess is that it probably has. I don't think I'm alone in thinking that. So we could draw all sorts of implications from it, right? One is that judicial education has become more important than ever as a means for keeping judges up to date on the course of the river. Here again, there's a lot more that could be said. I think the conversations yesterday were terrific and included many discussions of approaches that could serve this end, from things like individualized mentoring and coaching of judges by more experienced judges, to re-exposure to some of the theory and foundational knowledge underlying specific legal doctrines and concepts. I obviously don't have time to go into depth on any of those things, but I am pleased to have been asked to take part in this wonderful conversation, and I look forward to experiencing the rest of it.
Thank you very much for the invitation to participate in this conference, and I'm just delighted to be here. And I'm delighted, too, because this is not a field that I have any specialty in, so it's something that I'm going to learn a great deal about during the day. But it was fascinating to delve into it. Of course, I do have a background in an overlapping field, which is civil procedure, and that certainly equipped me, at least in part, to understand a little better what's going on in judicial education. But it's been a great pleasure, and again, thanks to Stacy, thanks to the Journal, and thanks to the law school for inviting me. What I want to do today is talk a little bit about the relationship between judicial education on the one hand and ideas and beliefs about law, courts, and adjudication on the other. Now, this topic and what I'm going to talk about kind of spans all three panels, which is why Chad and I decided to switch the order of our presentation, because Chad is much more focusing on the nature of judging, and I'm talking about the nature of judging. I'm talking about the nature of adjudication, but I'm trying to tie it into judicial education both historically and prescriptively. My working premise, and it's a basic one, is that what we do in judicial education should depend on not what judges do, even pervasively, but rather on what judges should do. And what judges should do can in part be influenced by what they do, but that can't be all there is to it. That is to say, what judges should do is not simply a matter of convention. This is not a matter of custom. It's not a matter of what judges are in fact doing. And so therefore, judicial education ought to tie into a normative view of adjudication, courts, of judging. Now, I'm going to make two claims in what I say this morning. One's historical and the other one's prescriptive. My historical claim addresses the question I find fascinating, which is why did judicial education catch fire in the 1960s and not earlier? As many of you I'm sure know and probably know far better than me, judicial education in the United States didn't really take hold and start to accelerate until about 1961 or so. And I'll have a word to say about that later. My answer to this refers to and relies upon ideas and beliefs that were prevalent during the 1960s. So it takes me back to my broader theme of what is the relationship between ideas and beliefs about courts, about law, about adjudication on the one hand, and judicial education on the other. This first claim, the historical claim, is a claim that maps a influence or of sorts causal relationship between beliefs on the one hand and judicial education on the other. So beliefs are influencing judicial education. My second claim is prescriptive. My prescriptive claim is that face-to-face, in-person judicial education is best justified as a device to invite and facilitate judges' critical reflection on what it means to be a judge. Here, the causal or influence link goes the other way. That is, judicial education has an impact on beliefs about judges. Beliefs judges hold about judging, beliefs judges hold about adjudication. So I'll have a word to say, of course, many more words to say about both ends of this. Now, one caveat at the beginning, and that is the content of judicial education courses is, well, sort of inaccessible to me, right? I go through the web and I see the titles of all these courses, and of course there's a huge number of them, and I try to make inferences about their content from their title. It could very well be that some of the things I'm going to say about judicial education courses are simply misplaced, because in fact the content of the course is different than what I would infer from the title. So I'm sure I will get corrections and I will hear more from you about what these courses actually involve. But I will nevertheless proceed forth in my ignorance of the content. Okay, first my historical claim, and then my prescriptive claim. My historical claim, again, is that during the 1960s, judicial education caught fire, partly because of prevailing ideas and beliefs about law, about courts, and about adjudication. First, the background. As many of you here know, and again, probably know better than me, judicial education in the United States didn't really start to take hold until 1956, when the NYU Institute of Judicial Administration held its first appellate judge seminar. Before that, there were some educational opportunities for judges, but they were sporadic, they were basically fairly minimal, and then NYU came into the picture and offered its summer seminar for judges, and that of course continues to today. This focused on appellate court judges, both state and federal. But judicial education didn't really start to take off until 1961, when the ABA, the American Judicator Society, and others organized something called the Joint Committee for the Effective Administration of Justice. The Joint Committee organized roughly 50 seminars between 1961 and 1964 for state court judges. The Joint Committee for the Effective Administration of Justice was chaired by Justice Tom Clark of the Supreme Court, who was an incredibly energetic figure during this period in starting, organizing judicial education courses of various sorts. So 1961, judicial education starts to take off. Before that, people didn't do very many programs. NYU had sort of started the judicial education movement in part, but it really didn't take hold until we got the Joint Committee involved. Joint Committee, with its 50 seminars, lasted between 1961 and 1964. And then in 1964, the National College of Trial Judges was formed, and it took over the task of providing seminars. And of course, the National College is now the National Judicial College. At the same time that all of these seminars were being held for state court judges for the most part, with NYU holding seminars for appellate court judges, both state and federal, federal district court judges were kind of left out of the mix. There were a few courses on various topics, but there wasn't a systematic effort to educate federal district court judges. But in 1967, the Federal Judicial Center was established, and it took over this task, and it started to offer a number of courses to federal district court and appellate court judges eventually. So these beginning aspects of the movement for judicial education really laid the seeds and built the energy for what turned out to be in the 70s a huge explosion of judicial education programs. So my question is, with this background, why the 1960s? Well, there are a number of factors at play here. For one thing, the congestion and delay problem was thought to be serious during the 1960s, both in federal and state courts. And judicial education was thought to be important in order to instruct trial court judges and also to some extent appellate court judges in how to better manage the congestion and delay problems, the backlog problems in the courts. But congestion and delay has been a perennial problem. Complaints about congestion and delay go way back. And in earlier periods, the congestion and delay concerns didn't precipitate judicial education programs. So the question's still on the table. Why judicial education in the 1960s and not earlier? Secondly, an important aspect of this story is Tom Clark himself, Justice Clark, who was incredibly energetic, as I said before, was involved very actively, believed deeply in judicial education, and was largely responsible for getting the funding and setting up of many of these programs. But again, well, Justice Clark was an important figure who took over in the 1960s. Nevertheless, his success and his enthusiasm for the project had to be a function, right, of other people being equally enthusiastic about this. His ability to get funding obviously meant that there were funding agencies who thought this was a very important thing to be undertaking. And again, we have the question, why the 1960s? Well, part of the answer to this, I think, has to do with ideas and beliefs about courts and adjudication that prevailed during the 1960s, coupled with another element. Two things are at work, I think. Two things, at least, I want to identify. One is the rise of and the establishment of process jurisprudence during the 1960s. Came to the fore in the 50s, became entrenched in a very strong way in the 60s. So what did process jurisprudence offer? Well, it offered really two things. One was a keen interest in the design of institutions. A shift, and I generalize here, from a concern about the nature of substantive rules, what substantive rules we have, to the design and structure of institutions that produce outcomes. And the thought here was, well, if we design our institutions well, over the long run, we'll get good results and good rules of a substantive sort. So a real focus on institutional design. The judiciary, the court system, was a huge part of this picture. Right? This was, well, we're all familiar, Longfellow and others in the process jurisprudence movement cared deeply about courts and adjudication. So adjudication as an institution was a keen focus of concern. Getting it to work well was hugely important in this picture. The second piece of process jurisprudence is that there was faith or belief that you could in fact find an optimal design for these institutions. You focused on the institution, and in fact it could be designed optimally. So put those two pieces of process jurisprudence together, you get a focus on the court system and a focus on adjudication, and confidence that in fact we could figure out some way to design the institution so that it worked better. Second big factor that enters isn't so much jurisprudential, but it influences, I believe, what's happening, and that's management science. Management science, operations research, and systems analysis, but primarily management science, really come into their own during the 1950s and 1960s. At that time, there was a belief that management structures and management of institutions obeyed certain general principles, and those principles could be ascertained really scientifically. It's quite clear in the literature, although it's not expressed as much as a historian might like to see to support his thesis. Nevertheless, there is certainly expression in the literature of a connection between court administration and management science. Management science offered models, business models primarily, for how to make courts work more efficiently. So management science as well offers, I think, two additional pieces to this picture. First, it reinforces the confidence that we can actually design court systems to operate better. And secondly, it offers models. It offers analogies, business models. The way businesses were being managed offered insights into how the courts could be improved. So during the 50s and 60s, and primarily the 60s I focus on here, what reformers are looking at primarily is court administration. And indeed, there's a sort of explicit shift from a concern about judges, or a view of judges, as making decisions and managing cases, to a view of judges as also responsible for and active in making the court system as a whole work better. So this is the period, for example, when people start talking about, gee, we need to hire court administrators. We need to centralize the court system, etc. Well, this court structure or court administration, I believe, came to the fore as an important item in the agenda because, at least in part, of the influence of process jurisprudence for institutional focus and the influence of management science giving models for how this might be done and confidence that it could be done better. Where does judicial education enter into this picture? It's quite clear that judicial education is thought to be essential to this reform movement. It's essential because you got to gather judges together and you got to convince them and excite them to change their court systems. You give them the tools to do so, the new insights, and you get them energized about doing it. And secondly, because there's a very strong pragmatic bent here, you get them an opportunity to share their own ideas and experiences, what they've learned that works well, and critically evaluate it with one another. So judicial education fits into this. And it's quite, as I say, quite clear actually in the literature of the period that people like Tom Clark, et cetera, see this tie between judicial education and court administration reform. So that first area really traces, and again historically, a causal link, or at least an influence, between ideas and beliefs about adjudication, about law, and about courts, on one hand, and judicial education on the other. The second part is a prescriptive claim. And the prescriptive claim, as I said before, works the causal link or the influence in the other direction. Today, of course, what courts ought to be doing and what judges ought to be doing is a contested matter. It's controversial. Of course, it was controversial back then, but at least there was a backdrop of some consensus about various elements. But today it's highly controversial. So you might teach in a judicial education program, for example, settlement promotion, but of course, why would you do that? You first have to decide what the role judges ought to have in settlement before you can teach the tools of settlement promotion. Same thing with discovery management. There's controversy about how much discovery ought to be managed, and therefore we have a prior decision to make about what judges should be doing with regard to discovery, how they should be involved in a case. So you've got a controversial set of issues about what courts should be doing, what judges should be doing. With that controversy, it means that we can't ground judicial education in the same kind of justification as during the 60s when there was more consensus about this. Secondly, and here's where I look at the web and try to infer the content of courses. It looks to me, when I look at all these courses on the web, that a lot of these judicial education courses fall into one of three categories. Many of them teach substantive and procedural law, it looks to me. You've got courses on employment discrimination. It sounds to me like you go to some seminar and you start learning about employment discrimination. Maybe this is a little risky to say in this company, but I don't understand why in-person, face-to-face judicial education is a very good idea for teaching substantive and procedural law to judges. Especially with the web. Stick it up on the web. The judge can look at it on the web, the judge can learn it in their own time, et cetera, they can get reinforced in that knowledge. I don't understand why that's a very effective vehicle for doing that. Secondly, some of these courses teach court administration in the same sort of way I just referred to it from the 1960s. That's certainly effective to teach. But again, I'm not sure in-person, face-to-face judicial education is the right way to do that if what's being taught is you could organize your court system better in the following way. A number of alternatives you could do with that. Now, what does that leave? Well, that leaves process skills and case management skills. So judicial decision-making, opinion writing, case management of various sorts. But that's precisely where the controversy lies, right? That's precisely where you need to have a prior theory of adjudication in order to figure out what you're teaching there. Again, the example of settlement promotion, the example of discovery supervision. So where are we left with judicial education at the end of the day? Well, one other thing we could do is what Chad mentioned, which is perhaps use judicial education to teach about cognitive biases, about situation sense. But again, I find that, while that might be a useful exercise, I find that rather hard, I guess, to do. And we could talk about that later. And that doesn't mean we shouldn't try to do it. It just seems to me it's difficult to do. So where does that leave us? Well, it strikes me that leaves us with, again, I'm focusing now on face-to-face, in-person judicial education programs. That the justification for that, the one that I find most appealing, is as a vehicle for offering an opportunity for judges to reflect critically on the nature of judging. What do I mean by that? Well, there are different theories of adjudication. Clearly don't need to get into them here, and in fact, different conceptions of adjudication that draw bits and pieces from these theories, right? There's a pragmatic theory of judging. Posner is famous for writing a lot about that now, but of course it goes back to the legal realists as well, and it goes back to a lot of other stuff. There's a pragmatic theory of judging, right? There's even an intuitive theory of judging, and then of course there's normatively directed theories of judging and adjudication, things like efficiency-based theories and rights-based theories. And again, really the best theory of the American system of adjudication is one that will draw. It's a hybrid. It's going to draw from different pieces of this in some way. But whatever the right theory of American adjudication is, it's not something that judges get to pick from a menu, right? It's not like we've got all these theories of adjudication. Well, I happen to be a judge who likes strict scrutiny, or strict construction. Yeah, so I'm going to draw this theory of adjudication that's good. That's not what it is. What we need to do is we need to offer a forum for judges who are well suited to deal with this, I think, if they're given the opportunity to critically reflect. To critically reflect on what kind of conception of adjudication both fits American practices, litigation practices, and provides a normatively attractive account of those practices. So a kind of reflective equilibrium, if you will. Fancy way of saying, I get to think with other judges about what American adjudication is. I think that is only effectively done face-to-face, in person, and in a group. That is, with other people checking and countering and criticizing your particular conception. It's very difficult to do on one's own. To try to figure out a conception or a broader theory of judging and adjudication that fits the sort of enduring elements of American litigation practice. But I do think that for judicial education, in my opinion, to offer anything that is of at least major value through the in-person, through the face-to-face vehicle, I think we need to first figure out, or provide an opportunity to figure out, what the best conception of American adjudication is. And again, it's going to be some hybrid, but it's got to be coherent in a loose way, and it's also got to fit American adjudication. And I, for one, would love to be present to see judges, again, this would have to be done artfully, engage in this kind of critical process. So, on the one hand, the historical claim, on the other hand, the prescriptive claim. Much more I could say. My time's up.
Thank you, Professor. So we are running right up against our time. However, I think that the presentations deserve at least one or two questions. And ready, set, go. Questions for our panelists?
Professor Oldfather, you talked about not becoming too fixed on what is measurable simply because that is what we can see, but also about this tacit knowledge, these unexplainable concepts. Did you have any ideas or suggestions for getting judges to start that dialogue?
Well, I mean, I think so. In this sense, I think Professor Bone and I are sort of pulling on the same oar in a sense that I would regard the face-to-face component of discussing the nature of adjudication as being something that could greatly facilitate developing that. And, you know, it's an inarticulable thing, but in some ways it would be equivalent to those figure skating judges sitting around in a room saying, well, you know, what are you looking for? And how do you focus your attention? And what does flow and effortless grace look like to you? They aren't all going to agree on it, just as no room full of judges or lawyers is going to agree on here's how we should go about judging. But I think that the conversation itself can at least build, if not consensus, sensitivity to other perspectives that can help shape one's own. So I don't know if that's fully responsive to your question, but I think just a little bit.
One more.
Of course, I'm always going to be ready to jump in. There's a moment here. Fantastic presentations from both of you. Wonderful. I really, really appreciated those. My question is for Professor Bone. You talked about this very interesting concept of the self-reflective discussion about some of these controversial issues and it needing to be very much a face-to-face endeavor. And we have a number of people in the audience who are professionals in the area of judicial education. Would you suggest to them that this is the type of thing that should be done in terms of a standard course within the context of their existing curriculum, or do we need a big conference type of situation, such as the Pound Conference on ADR way back when, et cetera? And I don't know if my dean is still in here, so I can't volunteer Missouri for such a large conference. But how do you see that happening optimally?
You know, I think it happens optimally in a course offered regularly as part. Certainly. I think if you do it in a big conference, it's not as effective because you want to have a group that's fairly limited in size. So you can have the kind of conversation I sort of have in mind, and I realize this is rather an ideal, I understand that. But it seems to me you can set the conditions better. You can facilitate the discussion if you have you want to get a person who can facilitate that kind of discussion effectively. And, you know, this is the sort of thing where a group of judges engaged in this process, and at the end of the day, one doesn't get unanimity, of course, but one, if nothing else, it focuses attention on this question. And I think we learn a little bit from it, of course, and hopefully a lot. But then you have different classes with different groups of judges. And then, of course, judges talk to one another, too. So hopefully you can sort of build a broader culture that way. But I think it's more effectively done through the smaller class.
Thank you.
Last question, Professor.
Thank you. I wanted to offer a comment for Robert Bone. I wanted to say that I'm strongly animated and strongly agree with your model of reflective, critical self-reflection. But I want to suggest that judicial education has other challenges and tasks as well. For example, looking at more basic educational needs, particularly in state elective systems, where frankly the threshold of competence maybe varies. And in developing countries that are going through transitional justice situations or whatever, the mandate, the purpose of judicial education may be much more basic than I think your elegant and extremely attractive critical reflection model. I like the critical reflection model, but I think it's looking at the top of the trajectory of what judicial education should do, driving judicial leadership, judicial thinking, and so on. I find it extremely attractive, but I think there are other functions for judicial education beneath that.
May I? So I have to defer, obviously, to your greater experience and expertise. As somebody who comes to this field, again, without any background, let me ask you a question. So, there must be sort of outcome measures and whatnot of this stuff. If you have like a 2-week course, perhaps they're longer, but a 2-week course in which you're teaching a judge, say, some very basic stuff, either a state judge or a judge in a developing country, what's the retention rate?
The retention rate of knowledge.
Yeah.
We do some elementary testing on that. You can do pre-post evaluation of knowledge gain, but it is only cognition. And of course, judging is much more than cognition. It can be skills, attitudes, values, and how they aggregate all of that. So the real answer from practice is that we don't evaluate methodically, systematically, or well. And it's a big space for further development.
This is the sort of thing where you say to yourself, well, okay, if I was sitting there, how much would I retain? Right? And I'm sort of, well, I don't think a lot. And so again, I think of the web, but of course, you're absolutely right. This is an area that my characterization is rather lofty. You're absolutely right.
Well, ladies and gentlemen, we need to move on to the next panel. I apologize. And let us thank our presenters for